Hello friends, we are going to analyze the AILET PG 2020 paper here. Friends, this year's AILET paper, especially with respect to constitutional law, was the most easiest of all times as per my awareness and my knowledge. Because out of 150 questions, we had around 30 questions this year, and this was absolutely based on the bare text of the Constitution. It did not require that vast, humongous knowledge of constitutional law as such. And anyone who has moderate knowledge of the provisions of the bare provisions of the bare text of the Constitution can definitely do well, at least in the constitutional law part of this paper. So moving straight away to the first question, that is the Constitution 104th Amendment Act 2020 has extended the reservation of seats for scheduled castes and scheduled tribes in the Lok Sabha and state legislative assemblies from options and the correct option, friends, I have underlined all the correct options. If you can just mark it with a light bluish color, and thus the correct option is definitely option C, that is 70 to 80 years. Friends, if I may just refer to that particular provision, I guess it's Article 334. Yes, friends, this was an amendment in Article 334, and as you know, Article 334 is the result of the legendary and landmark, what we call in modern history, that is the Pune Pact between Dr. Ambedkar and our own father of the nation, Bapu, that is Mahatma Gandhi. And this Article 334 was one one small sense of security that was secured to Dr. Ambedkar by Bapu himself, that to some extent, STs and SCs will have some representation in the greatest legislative bodies of this country, that is the legislative assemblies of the state as well as the parliament. And this particular Pune Pact fructified to some extent in this article. And initially, it was done only for 10 years. Then, by repeated constitutional amendments, this 10 years has got increased now up to 80 years. So, friends, this was the answer to question number one. The correct option is C, 70 to 80 years. Moving to the next question, the total number of judges in the Supreme Court of India, including the Chief Justice of India, at present is, friends, the correct answer is option D, that is 34. Initially, it was 31, including Chief Justice of India, but recently it was amended. This particular strength was amended in 20. Uh, the question also, there's again another question with respect to this. Perhaps 2020 amendment only. There was an amendment act, and the numbers were increased from 31 to 34. So, friends, you can see the questions are pretty much on the face of it, either in black or white. There is no gray question as such this year in constitutional law in the AILET paper. So, friends, moving to the next question. Again, it's a legal GK question. It's not even a law question. Question number three. The exchange of certain enclaves between India and Bangladesh, along with the conferment of citizenship, was carried out through the Constitution 100 Amendment Act. Friends, the correct option is option A. That is, in 2015, there was a constitutional amendment, and that was actually the 100th amendment. Moving to the next question. For the impeachment of the president, a resolution can be moved only after giving. That is, the correct answer is option B, that is 14 days notice. There has to be, there is a condition precedent before moving a resolution for impeachment of the president. That is, the house which moves the resolution has to give a advance 14 days notice to the other house, and then only the motion can be or the resolution can be moved. Friends, moving to the next question. How many fundamental duties are there in Part 4A? It's simple. The answer is 11. That is option C. Next question. Question number 6. When can the joint sitting of both the houses of parliament be convened? Friends, the answer is D. That is all the above. That is, when a bill is rejected by the other house, when houses are finally disagreed as to the amendments to be made in the bill, or also when more than 6 months have elapsed from the date of the reception of the bill by the other house without the bill being passed out. Move to the next question. A bill pending in the parliament shall not lapse. Friends, the options are pretty much simple. A, when the Council of States is prorogued. B, when the House of the People is prorogued. C, when a bill pending in the Council of States which has not been passed by House of People. And D, all the above. Friends, the answer is simple, all the above. That is option D. Moving to the next question. Question number 8. A money bill passed by the House of People and transmitted to the Council of States. The Council of States can do what? The answer is, the answer has to be out of one of these four, and the answer, it is pertaining to the action of the Council of States after a money bill has been passed and transmitted to it. So the correct option is definitely option C, because it is not that the Council of States cannot make any recommendations, so option A goes. It is also not that it can keep the bill only during the duration of the session. It's not necessary as such. And option D, it cannot delay more than 30 days. No, 30 days is the wrong time period. The correct time period is 14 days. So maximum within 14 days, if at all, the Council of States is to give any recommendation, it has to do so within 14 days. So option C is the correct answer. Moving to the next question. Who will decide if any question arises whether a bill is a money bill or not? As simple as that, the option is Speaker, that is option C. The minimum number of judges in the Supreme Court required for purpose of hearing any reference under Article 143 is option C, that is 5, at least 5 judges. The next question. Who can be removed from office in like manner and on the like grounds as a judge of the Supreme Court? Definitely the correct answer is the CAG, that is Comptroller and Auditor General of India. That is option B. The protection is given because generally CAG is a constitutional authority which is there to check the excesses and the vices of the executive of the day. Thus, that particular office needs that constitutional protection, which will at least ensure its own impartiality, its own fairness. And definitely, the protection granted to a Supreme Court or a High Court judge is that level of protection which will ensure the same. Thus, option B is the correct answer. Moving to the next question. Question number 12. Under Article 200 of the Constitution, when a bill is passed by the State Legislative Assembly and presented to the governor may option A, assent to the bill. Option B, withhold the assent. Option C, reserve the bill for the consideration of the president. And option D, that is either A or B or C. Friends, the correct option is option D, because all these three courses of action are the probable courses of action that can be adopted by the governor, but definitely either of that, not all together. So either A, either B or C. So the correct option is option D. Friends, moving to the next question. Which provision? I'm sorry, it's not visible as such. Uh, I may read that question. Which provision, definitely of the Constitution, authorizes the Parliament to make a law to remove the jurisdiction of the Supreme Court? Friends, Article 262 provides for the establishment of Interstate Water Disputes Tribunal, and as we know, that is the single forum whose order, whose judgment cannot be questioned ordinarily in any High Court or Supreme Court, except definitely Article 136 is a resort to that. But Article 262 Clause B specifically provides that, Clause 2 actually specifically provides that Parliament may by law provide that with respect to any matter of interstate water dispute, no court, no Supreme Court, no High Court shall have any jurisdiction. It is specifically provided in Article 262 Clause 2. Thus, this is the answer, option A, which provides or which empowers the Parliament to at least bar the jurisdiction of the Supreme Court or High Court with respect to interstate water disputes. Moving to the next question. The Interstate Council was established under, definitely the correct option is option B, that is the Constitution. Article 263 provides for the same. Moving to the next question. The Constitution of India came into force with effect from 26 January 1950 based on, the correct option is option 394. Article 394 provided that some articles shall be enforced immediately. If I may read those articles for just a bare reading of the same. Yeah. Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392, and 393. These are some of the articles which were provided that they shall come into force immediately at once, and the rest of the constitution shall come into force on and from 26 January 1950. So the correct option is option B. Moving to the next question. If an amendment to the first schedule to the Constitution is made to change the name of a state, then the procedure required is definitely, friends, the option is option C, that is simple majority of both the houses of parliament. Article 3 provides for the same. Article 3 and 4 cumulatively deal with that topic also. Moving to the next question. Question number 17. That is, for the first time in India, one of the houses of parliament passed a resolution for the removal of a judge. Who was the judge? Friends, it was Justice Soumitra Sen, and I would like to inform that it was Rajya Sabha which actually passed a resolution for removal of that particular judge. And at that time, surprisingly, Arun Jaitley was the leader of opposition at that time, and he also vehemently advocated this cause for removing that particular judge, because there were allegations of huge corruption against him and disproportionate assets also in his favor. So this was the answer. Option B, that is Justice Soumitra Sen of Calcutta High Court at that time. Friends, moving to the next question. That is question number 18. That president can promulgate an ordinance under Article 123 if, definitely the answer is option D, that is both Council of States and House of People are not in session. Friends, the power to promulgate an ordinance is not an ordinary legislative power. It is that legislative power which is to be called into effect only in case of urgency or emergency, and that is definitely indicative that when neither of the house of the parliament, that is neither the Lok Sabha or Rajya Sabha, are in session and some urgency comes up, definitely that is a fit situation to bring into effect the ordinance power of the president under Article 123. So the correct option is option D. Friends, moving to the next question. That is, a presidential election can be challenged only in Supreme Court. So option B is the right answer. 20. Option A is the right answer, my friends, because the doctrine of eclipse was actually first time used to interpret Article 13 clause 1 only. Let's move to the next question. The doctrine of severability was extended to constitutional amendments as well by the Supreme Court. In, whereas the correct option is option D, that is Quixote Holohan versus Rashilu. Friends, as you also know, that Quixote Holohan case is the landmark case of 10th schedule. It was the first case in the Supreme Court in which the 10th schedule itself was impugned, and the particular amendment was also challenged. Friends, here severability was applied by the Supreme Court in the sense that para 6 of the 10th schedule provided, if I'm accurate in that sense, let me confirm. Yeah, para 6 provided that decision on questions as to disqualification on ground of defection. Basically provided that in matters of disqualification of members of parliament, the decision of speaker is final and binding and cannot be called into question in any court of law, precisely at least any high court or Supreme Court. So friends, the Supreme Court, it held that this particular provision is definitely unconstitutional as it goes beyond the pale of the parliament to bring an amendment in such a manner. And as we know, in the landmark case, that is L. Chandra Kumar case, which overruled the Sampath Kumar case. In that case, it was held, L. Chandra Kumar versus Union of India. In that case, it was held that the provision that was provided in the Administrative Tribunals Act and also in Article 323B, for instance, if I'm precise in that sense, Article This is a 323A or 323B. Yeah, Article 323B. Article 323B. It is provided, if I may read, that a law made under this clause, that is clause 1 of Article 323B, provide may exclude the jurisdiction of all courts except the jurisdiction of Supreme Court under Article 136 with respect to all or any of the matters falling within the jurisdiction of the said tribunals. So only the SLP jurisdiction of the Supreme Court under Article 136 was saved by this amendment. And this amendment empowered the Parliament to exclude the jurisdiction of Supreme Court under Article 32 and exclude the jurisdiction of the High Court under Article 226 of the Constitution. So the Supreme Court in the L. Chandra Kumar case held that writ jurisdiction of Supreme Court and High Court are form of basic structure of the Constitution. Thus, it cannot be in any case removed or deleted from the Constitution, or it cannot be also impeached. It cannot be breached by any state action. Thus, friends, in this sense, the Supreme Court in the Quixote Holohan judgment also held that in no case can a particular amendment provide that the jurisdiction of the Supreme Court or High Court can be taken away, because it also held that, that the Speaker, while acting under para 6 of the 10th schedule, acts as a quasi-judicial authority. And since the Speaker acts as a quasi-judicial authority, that is like a tribunal, specifically to say, it is subject to judicial review, at least if not to that extent, but to a minimal extent of judicial review, that is lack or excess of jurisdiction or want of jurisdiction or abuse of jurisdiction or even malified action, or again reiterating the Wednesbury principle, that is taking any irrelevant consideration into mind while deciding the case, or leaving any relevant consideration while deciding the case, and which is completely random and arbitrary. So these are some of the limited grounds upon which the action of the Speaker is subject to judicial review of the Supreme Court and the High Court. And thus, the Supreme Court, while holding the whole 10th schedule as constitutionally valid, especially para 2, which is the main provision requiring defection of the or disqualification of the members upon all the prerequisites provided there, it held it constitutional, and it held all of the provisions constitutional only while holding this particular provision, that is para 6, as unconstitutional, that is beyond the pale of the Parliament, and it modified it in a sense that it read the office of the Speaker with respect to power under para 6 as a tribunal and as a quasi-judicial authority. So here the doctrine of severability was invoked by the Supreme Court, and it was the edifice upon which the Supreme Court decided the whole case. So friends, I hope this is clear. So moving to the next question, that is question number 22. That is, proclamation of emergency means a proclamation issued under, friends, the answer is Article 352, because Article 352, which we often call as national emergency, is actually proclamation of emergency. And what we call state emergency is actually, in legal terms, it's not state emergency, it is President's rule under Article 356. And Article 360 talks about financial emergency as such. So technically, proclamation of emergency, or even actually under Article 356, the more official and legal term is failure of constitutional machinery in the state. That is the precise term. And you can also call it President's rule in the state, but it's not emergency as such. So emergency is generally associated in the kind of emergency envisaged and enumerated under Article 352. So option A is the right answer. Let's move to the next question. That is, the total number of members in the Legislative Council of a state shall not exceed, friends, the answer is option C, that is 1/3 of the total number of members in the Legislative Assembly. Moving to the next question. The process of proportional representation by means of single transferable vote is not used in the election of, friends, the correct answer is option C, that is Legislative Council. Next question. Paragraph 3 of the 10th schedule was omitted by, friends, the correct option is option C, that is the Constitution 91st Amendment Act 2003. The next question, precisely, friends, as this question I earlier said that perhaps it is linked with question number 2, that is, the total number of judges in the Supreme Court, including the Chief Justice of India, was increased to 34 by, the correct option is option D, that is the Supreme Court Number of Judges Amendment Act 2019. Yeah, I said it 2020, it's actually a 2019 Amendment Act. Friends, the next question, that is question number 27, the power to prorogue the House of the People is exercised by, the correct answer is President, that is option A. Friends, mark the word, it is the power to prorogue, it is not the power to adjourn. The power to adjourn is question number 30, which I will come to. definitely. But here the question is that is power to prorogue, and the power to prorogue lies with the president, not the speaker. So option A is the correct answer. The next question, a member of parliament disqualified under the anti-defection law is also disqualified to be appointed as a minister is provided for by which of the following thing? I mean, 10th schedule or rules of the House or convention or the 91st Constitutional Amendment Act. Friends, the correct answer is option D. That is the 91st Constitutional Amendment Act. Friends, this constitutional amendment amended Article 75, Article 164, and Article 361. And by such amendment, it inserted Article 75 1B, Article 164 1B, and Article 361 B. By all these three new articles, it introduced another bar for all those members of legislative assemblies and members of parliament who are disqualified by virtue of defection under the 10th schedule. The bar or the additional disqualification was the additional liability was that one who has been disqualified by virtue of 10th schedule, whether MLA or MP, he or she cannot become a minister up to the period where he or she gets re-elected, or or up to the period uh, which is ordinarily the period of the legislative assembly, had he or she been the member. If I give an example, consider an MLA. If he gets disqualified by virtue of defection, then he has two options. Either he gets re-elected by again fighting the election, or he does not do so. Now, till the time he has got re-elected, or till the time 5 years has elapsed from the date on which he was actually elected originally, either of the time, any time which gets passed earlier, till that time he cannot be a minister. So he cannot be a minister till he gets re-elected, or he cannot become minister till 5 year time period passes, whichever is earlier. This is the additional sanction which has been put to those MPs and MLAs who have got disqualified by virtue of defection under 10th schedule. Friends, moving to the next question. That is question number 29. The Council of State enjoys co-equal power with House of People in. Thus, the correct option is option A, that is constitutional amendment bills. Friends, again, as I just observed earlier, the last question pertaining to constitutional law, that is question number 30. The session of the House of People is adjourned by, the correct answer is C. Friends, the power to prorogue is with the president, whereas the power to adjourn the session of the House is with the speaker. So friends, till this, we have covered the constitutional law part of this paper, and I hope and I also have observed that this year's constitutional law part of the AILET paper was perhaps the easiest of all times, and anyone who has a moderate knowledge of the constitutional law can definitely or would have definitely done well in this paper. The friends, I hope that all those who have appeared for this paper have done well, and I also suggest to the upcoming batch, that is who are aspiring and who are preparing for the AILET 2021 PG exam, they shall now expect at least one level more difficult questions in the next exam, because this year's threshold of difficulty, at least with respect to constitutional law, was very less, and thus it was a very easy paper. And because we can also know that due to the disturbances in this year, and AILET specifically, who had already decided to conduct the exam at home, that is online, and again refrained from that position and again went back to its original position of online at center-based exam. So definitely there are many hodgepodge in this particular conducting of this exam, and thus some parts of the paper were pretty much easy. One of which is definitely the constitutional law. So I would suggest the preparing students for the upcoming 2021 exam, IELTS exam, that they shall at least now prepare well, at least for the constitutional law, and they shall not only expect questions from simple bare provisions as it is in the present case. So friends, with this, I end this video, and I also wish best of luck to all those students who are preparing for the upcoming year's exam. And definitely, we, Lex Templum, will be bringing more videos, and we have also started our various courses for CLAT, PG, LLM, and also IELTS and also DU. So I would just recommend to all the students to kindly visit the Lex Templum website, check all the types of courses, and also subscribe to them as per their own convenience and their own aspirations. So, friends, with this I bid goodbye. Thank you.